Okay. Greetings, everybody. Keith here, hoping everybody's having a good day, enjoying life, living life, loving life. I'm going to go over some more of the Iowa Master Custodial Agreement. We're going to start off where we left off last night, but we're going to go over something else real quick before we do. And before we get started with that, I want to remind everybody, hit that like, share, and subscribe button. If you're on Hecklebus, get over to El Perro and do the same. And if you're on El Perro, get over to Hecklebus and hit that like, share, and subscribe button. There is a PayPal link down there for anybody who wants to share some love. The StreamYard link is down there for anybody who wants to come and join the panel. And we're going to get started with frequently asked questions about government contracting careers. It says, what is a contracting officer? A contracting officer is a person who can bind the federal government of the United States to a contract. A contracting officer is a person who can bind the federal government of the United States to a contract. Contracting officers hold a warrant that allows them to negotiate on behalf of the United States government. Remember our reading last night about the inland marine installations, the post offices, and they were warrant officer postal criterias. They're the contracting officers that can bind the federal government to a contract. As the government's agents, only COs may execute, modify, or terminate a contract. As the government's agent, the United States Postal Service registered agent. As the government's agent, only COs may execute, modify, or terminate a contract. Are you supposed to be addressing the government in those courts? Like I said, those are administrative courts. You're not supposed to be addressing them if you want to fix the record. There is a need for contracting officers both domestically and overseas, depending on the agency. Responsibilities. Contracting officers are responsible for ensuring that the government obtains value from contracts. All requirements of law and regulation are met prior to executing an action. Prior to executing an action. Sufficient funds are available for obligation. Contractors receive impartial, fair, and equitable treatment. Both parties comply with terms of the contract. As the government's agent, only COs may execute, modify, or terminate a contract. So it's the contract officer, the person that bound the federal government of the United States to a contract, who held a warrant that allowed them to negotiate on behalf of the United States government. As their agent, As the United States government's agent, only COs, contracting officers, may execute, modify, or terminate a contract. So if there's a contract and you've got that ID in your pocket, you're the one that they have the contract with. The contract officer is the one that can allow that contract, modify it, or terminate it. So what's the state doing? State's the one making the offer of that contract. And then when it's actually valid, you're the one that puts the address to it. You're the one that gives them the address. And now the contracting office, post office, says, oh, he's one of our agents. He's a common carrier. He's insured. The interests of the United States are safeguarded and taxpayer money is spent wisely. The interests of the United States are safeguarded. So you have to put everything in the interest of the United States in order for that contract to be safeguarded. It's not for the interest of the state. It's in the interest of the United States and taxpayers' money. Contracting officers work at every government agency and acquire everything from nuclear carriers to office supplies. Everybody understand that? Office supplies. First, I want to take a moment to greet everybody. JLV greetings, Jack off Jack. Thank you. Thank every Jack of Jack. I changed it. Jack of Jack. Angry Rooster, Jeff Pizer, Austin Murphy, greetings, everybody. Anybody else that's out there, greetings. If you're on Facebook and you want to join the panel or anything, you have to go over to the YouTube. Join the chat there. The link is pinned. Let me make sure, double check everything. Yes, the StreamYard link is pinned. Let me grab the PayPal link for anybody that might want to share some love, and then we'll get back to it. Veracid Piranha Divine, greetings. Greetings. All right. So back to the master custodian agreement. Last night we left off with this: the custodian agrees, and each pledging bank agrees to cooperate with the custodian to ensure that all collateral credited to the securities account shall be registered in the name of the custodian or endorsed to the custodian. And in no event will any financial asset carried in a securities account be registered in the name of a pledging bank, payable to the order of a pledging bank, or specially endorsed to a pledging bank, except to the extent such financial asset has been endorsed to the custodian or in blank. So when it's been endorsed to the custodian is the person. And then when you endorse that check, you're supposed to make a special qualification on it. Otherwise, if you don't and you just sign it, that's called signed in blank. And now they can take that and pledge it. They can take it and pledge it. So all those checks that you thought you were depositing, for instance, back when I was a young kid and I had my first paper up, the checkbooks I had a carbon copy. So, or had a regular It didn't have a carbon copy. And so you just rip the check out and you present it. Whoever got that check would take it to the bank, cash it. When the bank cashed that check, they would send the issuer that check back. They would cancel that check and it would come back to the issuer. Then they changed to checkbooks where they have, you write the check, you rip the check out, it goes in, and you keep a carbon copy. They get the original and don't mail it back to you. That's a security. That's a bond paper. Those checks, those are written on bond paper. Think about it. With respect to securities that are in book entry form, book entry form is the electronic system. The electronic system today is the extensive record from all of the paperwork. And the paperwork is the definitive entry form. And they're switching over to a book entry form entirely as much as they can. They're still going to have to do paperwork. They're still going to have to use paper money. Okay? So this digital reset and all that shit about fearing about the financial dollar and all that being electronic only, they can't do that. That's going to supersede the Constitution and the mint. Okay? The mint. See, if you take away the property and make it nothing but electronic and there's no actual asset, then there's something wrong. So they have to leave the asset there. Okay? The thing that backs the paper, it's got to be there. The custodian agrees, and each pledging bank agrees to cooperate, With respect to securities that are in book entry form or are held at DTC or another securities depository, which tells you that the DTC is a securities depository. Okay, that's where they deposit the securities. Delivery shall be effected in compliance with the requirements of the applicable federal law and regulations. So they're holding on to those securities when the state issues securities and bundles them up. They've got to go to the DTC. So they do know, they do have a notice. They do have interest. And they know there's interest on that shit. The rules of a Federal Reserve Bank governing securities maintained in book entry form at a Federal Reserve Bank and the rules of DTC or other applicable securities depositories governing securities maintained with DTC or such other depository in book entry form. So it's not the money that everybody thinks it is. The paper. They're trying to reduce the use of paper. They're trying to reduce the use of paper. And we've got all these gurus and idiots out there trying to teach other people how to write these 90-page affidavits and file document after document after document. And it's just fucking stupid. If at any time the custodian shall receive any entitlement order from the treasurer relating to the collateral, the custodian shall comply with such entitlement order without further consent by any pledging bank or any other person. So you go to the DOT, you get a birth certificate from the state. That's a document of title. The state performs a contract. Contacts the treasurer to make sure that birth certificate is correct, because that's relating to the collateral. The custodian shall comply with such entitlement order, and that is the license. You go on the DOT, you take your test and everything, fill out all the documents, you give them that birth certificate and a Social Security card, and they get all that information, and that's what allows them to determine that you're entitled relating to the collateral. And that collateral is that security certificate, or in the book entry form, the electronic record that the treasurer holds. It says, yeah, he's a contracting officer. He can do that. He's claiming to be a resident using the address. The custodian agrees not to take any act that would permit a person other than the treasurer to have control of the collateral. Such term is defined in the UCC. If the treasurer delivers to the custodian written notice that in the event of default under the pledge agreement has occurred, the custodian shall cease complying with entitlement orders or other directions relating to the collateral originated by the pledging bank or any person other than the treasurer with respect to the collateral delivered by such pledging bank. So, if the treasurer delivers to the custodian written notice that any event of default under pledge agreement has occurred, the custodian shall cease complying with entitlement orders or other directions. So when that officer gives you a citation alongside the road, he is not the treasurer. And this is the violation of process due. They're supposed to use diplomatic channels of notice, and that means they're supposed to notice the treasurer. Hey, treasurer of the United States, under the Government Services Administration, we plan to file a suit against this person right here. He used this address. Can you verify with us that he is in fact a resident? Then the treasurer is supposed to verify that, yeah, he's a resident, and send them back notice that, yes, you can sue them, and then send you a notice that, hey, this guy intends to sue you. That's the way that's supposed to work. 22 US or 22 CFR 93.1. 22 CFR 93.1. Yep. Copy paste. It's in the chat. And greetings, Moon Peach, Disciple the Messiah, Pale Horse Rider, greetings. Moon Peach says, biodigital signatures are cryptographic proof systems that can help in establishing trust on the perpetual debt CBDC blockchain. Yes. Yep. That's why I've got my own site. I'm learning as much as I can about the private blockchaining, because that's where your value is going to start coming from. Instead of being backed by some substance of materialistic value of gold or silver, it's going to have to go by your story. And the better you write your story, the more value you're going to have. The more people are willing to read it. Therefore, it's going to have more value. More people will be generated to your site. See how that works? That's your digital currency. That's your digital value system. This system wants as much information as it can get. It's thirsty. It's just ready to gorge on information. But if the people put in the proper information, imagine how much it'll change on the external paperwork that people are following through all these policies and everything. The more laws you have, the more ignorant people get. Because the more there is to read and the less they want to read, so they don't read at all. And I've said this many times. It's a shame that our younger generations don't pick up a book after they graduate from high school. I'm not going to say that across the board, but a large portion of our younger generation does not pick up another book after they graduate high school. And that's sad. At no time shall a pledging bank be entitled to withdraw or substitute collateral other than in accordance with Section 5 hereof. Section 3, waiver of set-off. Notice of adverse claims. Subordination of lien. This is when they're filing that suit, when they issue that ticket. They're supposed to give you these notices so you can waive the set-off. That's telling you you have a right to set off. The collateral will not be subject to security interest, deduction, set off, banker's lien, or any other right in favor of any person, including the custodian, other than the treasurer. They maintain priority interest in that security because they are the issuer of that security. That interest is the interest in the obligation, and that is what you're setting off. That is what you're discharging. You're discharging them of their obligation. At the same time you discharge of them of their obligation, you're releasing credits. If any person asserts any lien, encumbrance, or adverse claim, including without limitation any writ, garnishment, judgment, warrant of attachment, execution, or similar process against the collateral, the custodian will promptly notify the treasurer thereof. We're supposed to give the notice. We are the ones acting as trustee, custodian, holding that license. Therefore, we're supposed to get a hold of the treasurer. So when that nice policy officer pulls us over alongside of the road, we have to give a call into the treasurer. Treasury offset is what I would call. Since it's a set off, I'd call him right up and say, hey, I got this nice gentleman alongside the road that would like to pose a public debt or a public or private debt against that number. Diplomatic channels and notice says I'm supposed to give notice. Diplomatic channel. That means I'm supposed to call the treasurer. That's the case in all cases. No one is supposed to be able to perform any of these contracts without contacting the treasurer. In the event that notwithstanding the foregoing, the custodian has or subsequently obtains by agreement, by operation of law or otherwise, a security interest, right of deduction, right of set-off, banker's lien, or other right in the collateral, the custodian hereby agrees that such security interest or other right shall be subordinate to the security interest of the treasurer. So your security interest is in the right of set-off, right of discharge. You have the right, as an ally of the nation that's placing the charge, to say, no. We've already agreed not to charge each other. Da-da-da-da-da-da-da. Charge! We've already made a peace agreement. We've already decided not to charge each other by operation of law. So by operation of law, when that officer stop you alongside the road and wants to issue a traffic citation, and you wish not for it to go through that process because that's the wrong process, you can send that to the treasurer and let them know, hey, this guy's creating a security interest. I'm handing the interest over to you because I have a subordinate interest in this financial instrument under negotiations. Warranties and covenants of custodian. The custodian makes the following warranties and covenants to the treasurer. The custodian is a financial institution. Under 39 CFR 387.5, I think it is, definitions, there's one under there about person or persons, and it talks about financial institutions. So anywhere that license is, if you have that license in your wallet, you are claiming you are a financial institution. It's got an address on it. That's a financial institution of a contract officer, one that can bind the United States government, the federal government, to a contract. All you have to do is learn how to bind them to that contract. Or if the custodian would qualify as a financial institution except that it is organized under the laws of a state in the United States other than Iowa, The custodian has delivered to the treasurer a legal opinion. A legal opinion. That's all they are. Every last one of us, nothing but a legal opinion. The case law is a legal opinion. Look at it. It will say opinion. It is not law. Legal opinion satisfactory to the treasurer, prepared by counsel for the custodian, licensed to practice in the state in which such custodian is principally located, regarding to the compatibility of the UCC with the Uniform Commercial Code, as adopted in such state, unless the treasurer has waived such requirement in writing. Problem with that is that you have to be organized under the laws of the state or the United States. And all of the states, you have to be organized under the laws of the United States. This means you have to have an organizational certificate from the Federal Reserve showing that you have communicated your intent to perform commercially, how you are corporately structured with the board of directors, and that you can hire a counsel for the courts, and that you have that legal name structure. If you don't have that, sorry, you cannot be the actual custodian. You may have custody, but you are authorized through a custodian to do so. And the custodian maintains these responsibilities and these liabilities, not you. That's why UCC 3-402 says the authorized representative who is representing what is in custody, which is the record. And you only, like I said the other day, you only hold a portion of that record known as a license that exposes the rest of the record that is with the custodian. And so when UCC 3-402 says the authorized representative giving an unambiguous signature on the instrument is therefore not liable for the person named in the instrument. You do not give notice to the trustee of the bank, Sam Gold. It's telling us right here, you give notice to the treasurer. The trustee of the bank does not know what the hell they're doing. And the notice is that you are not the custodian, of which they are treating you like the custodian simply because you have that little ID. The custodian is the one that has custody of the entire record. You only have custody of a portion of the record. The custodian is the treasurer at the DTC that holds the electronic book entry record. It's an electronic record. Okay? That's who you're supposed to be communicating with. And those loans are not loans. Again, how do you get a loan from a bankrupt corporation? Figure it out. You're not supposed to be touching those documents, folks. Those are administrative documents. You're supposed to be communicating privately with the treasurer. 22 CFR 93.1, diplomatic channels of notice, because you are foreign. Ask the banker, am I foreign to the bank? He's going to say yes. Please. The securities account has been established as set forth in 2.2 and will be maintained in the matter set forth there herein until termination of this agreement. So it's the termination of the account. I cannot stress this enough, people. I cannot stress this enough. The correction of the record is the termination of the account and establishing of a new account. Not an administrative account through a banking system, but a trust account through the judicial office. I don't know anybody that's done this yet. No one. That's what I'm working on now. And I'm showing you exactly where everything comes from. So don't be misled. 22 CFR 93.1. Okay. And real quick, a reminder, hit that like, share, and subscribe button to help the algorithms. Be sure to hit that PayPal link if you can share some love. And if you're on Hecklebus, get over to El Perro and do the same. And likewise, if you're on El Perro, get over to Hecklebus. Hit that like, share, and subscribe button. The StreamYard link is down there pinned. So anybody wants to join the panel, and we're going to get back to it. Okay. The custodian shall not change the name or the account number. The custodian shall not change the name or the account number of the securities account within the prior written consent of the treasurer. Custodian shall not change the name or the account number. Now, when I went down to that courthouse and had 93 cases down there, all those appearances, that custodian down there used an account number that looked exactly like the Social Security account number, except that it had no dashes. So if it's got a different number, it's a different account. Social Security account is for the last name. The firm account is for the obligor number. The obligor number is a conversion of the Social Security number. And again, they're drawing from a different account. They're drawing from a firm account and not the actual Social Security account. All items of income, gain, expense, and loss recognized in a securities account shall be reported to the Internal Revenue Service. Income. In order for there to be any income, you have to first invest in something. In other words, you have to take your Federal Reserve notes or your asset and pledge it as an investment. Now they do it all backwards down at the court. They tell you it's a fine, fee, or penalty, and you got to pay it. But the reason they tell you that is because they already issued a bond and it's not backed. See that gold clause when they took all the gold out? Nothing's backed by gold. So it's backed by your signature. So they get the signature first, issue that bond, and lo and behold, now you got to back that bond. And if it's a big enough bond, they throw you in jail and you have to get a bail bondsman to write you a surety bond to get you out of jail so you can act as surety. Now you're in trouble. Reported to the Internal Revenue Service and all state and local taxing authorities under the name and taxpayer identification number of the pledging bank at issue. Name and taxpayer identification number. Custodian shall not change the name or the account number. This is a name and taxpayer identification number. So you give them a taxpayer identification number, which is Social Security number, and they apply it to a certain account. And that account number cannot be changed. So there's an account running around for your securities because you're the one signing them, executing them as a contract officer. And this is all a presumption of the legal name and the taxpayer identification number of a financial institution known as a pledging bank. Tell me they're not treating you like a bank. Tell me you're not acting like a bank. Tell me you don't think you know how to bank just because you got somebody else with a bank account for you. That's kind of fucking dumb. The custodian has the corporate power and authority and the legal right to execute and deliver and to perform its obligation. See, the obligation is one of performance under this agreement. The obligation isn't the charge. That's what you get to set off. That's what you get to discharge. Full acquittance is for the obligation and has taken all necessary corporate action to authorize such execution. The Social Security card is an authorization. The driver's license is an authorization. You go down to the bank, they give you an authorization. All of these people are custodians, and they're giving you authorization to copy and duplicate them. And you act just like it. You walk right up and say, okay. They'll even tell you what to put on their forms. Here, you fill this out, and you need to put your first name here, your last name here, da-da-da-da. Don't do this and don't do that. They never tell you that you can lie on a veto through the whole thing and just rewrite it. Because they don't know this themselves. Delivery and performance. This agreement constitutes a legal, valid, and binding obligation of the custodian, enforceable in accordance with its terms. Of the custodian, enforceable in accordance with its terms. Again, if UCC says you're not liable for the person named in the instrument, then what is the enforcement? You see why I question things, folks? Except as enforceability may be limited by applicable bankruptcy, insolvency, reorganization, moratorium, or similar laws affecting the enforcement of creditors' rights. Now you see what they're enforcing. Aren't you the creditor? Doesn't it tell you in Deuteronomy 15 that you're supposed to be the lender unto the nations? And what are you supposed to lend unto them? The data elements. You're supposed to profit unto the nations, Jeremiah 1:5. You profit unto the nations is the data elements, and that's what you're lending them, is the paramount greater truth, a better credence. Except as enforceability may be limited by applicable bankruptcy. Remember, I said these people are bankrupt, right? That's the limitation, and nobody applies it. If a business is out of business and has no assets, then they can't even enter into the fight. Remember the old the thing, in order to receive equity, you must first bring equity. In order to get in a fight, you got to have fight. In order to be able to get paid, you have to have something to pay. If you're bankrupt, you ain't got no business walking into a bank except to get a loan. Guess what? That's why you don't belong in a bank. You're not the one that's bankrupt. Why would you go to a bank unless you were bankrupt and couldn't do your own banking affairs? You don't need a bank. You just learn how to do the banking. Generally and by general equitable principles. If you want equity, you must first come with equity. So in order for you to be able to conduct affairs with a bank and say you want to walk in and get a loan, you should have something on deposit where they would draw that loan from. The only purpose for a real bank and a loan is to prevent yourself from being a spendthrift and spending everything you have. It's basically an accountant who says, hey, wait a minute, boss. You've already spent this much this month, and that's a little out of range. That's why people say, fuck it, and chase the bag. And the more they can get that bag, the more they can spend and say, fuck it, I don't care how much I spend. I can be a spendthrift. No, the importance about the talents is that you go forth with talents and come back with more talents. Not just to have enough so you just throw everything out there. Don't make all kinds of money and then just give it away. It's like the fish. You feed a man for a day if you give him a fish. So you're going to feed a man for a day if you give him some money. But you're going to feed him for a lifetime if you teach him how to get that money. Again, though, the principle in the lesson is not just to teach them so they can get it themselves, but so they get over the selfish part and teach others how to get it for themselves. So you don't have to keep trying to get it from everybody else. You have your own talents to get that fish. Whether enforcement is sought by proceedings in equity or at law. This is where your enforcement comes from. Those administrative courts have zero enforcement. They are not courts of equity or at law. The execution, delivery, and performance of this agreement will not violate any provision of any law, statute, rule, or regulation, or any order, writ, judgment, injunction, decree, determination, or award of any court, governmental agency, or arbiter presently in effect having applicability to the custodian. Enforcement is sought by proceedings in equity or at law. This is a contract, then it's under arbitration. It's not for filing a suit in an administrative court. It is an arbitration. Contracts imply automatically arbitration. Like I said earlier, it's the armistice. You do things in agreement, not in war. You don't turn around and start charging each other. The custodian has not entered into, and until the termination of this agreement will not enter into, without the prior written consent of the treasurer, any agreement pursuant to which the custodian agrees to comply with entitlement orders with respect to the collateral of any person other than the treasurer or applicable pledging bank. So these are the only places they can get their collateral. So if you're not the treasurer, obviously, they're deeming you as a pledging bank because you're acting like a banker going around telling everybody your shit. You go around telling everybody all your business. Sounds just like a banker. Fucking snitch. Purporting to limit or condition the obligation of the custodian to comply with entitlement orders as set forth in Section 2.4. The custodian is a securities intermediary. The custodian is a securities intermediary as defined in Section 8-1021N of the UCC and is acting in such capacity with respect to the securities account. The custodian is not a clearing corporation. They cannot do anything to clear up any issues. They cannot do anything but follow what is put before them. So you have to take it out of their hands. You cannot allow them to keep doing this shit in the administrative courts. The custodian maintains book entry accounts. The custodian maintains book entry accounts with a Federal Reserve Bank and is either itself or through a sub-custodian, a direct or indirect participant in DTC. So as I said, you're being treated as a custodian because you took upon that paperwork. You took upon that application, that registration, that license. Those are all things known as negotiable instruments that can be securitized. If you're not going to securitize them yourself, the custodian will, and they will issue the liabilities to you. The custodian is not and shall not be at any time an affiliate of a pledging bank. Provided, however, that in the event the custodian becomes an affiliate of a pledging bank subsequent to the date thereof, the custodian shall immediately notify the treasurer. So when you open that bank account, did you notify the treasurer? You were acting as a custodian, right? Now you wanted to act like a bank. So you're supposed to give the treasurer notice. Hey, I don't want to act like a custodian anymore. I want to act like a bank. That's the duality. You're acting like a custodian and a banker. Secure the services of a successor custodian. Born in a spell of illness, bearing successor custodians. Did you teach them how to clean up? You know, the school custodian? Everybody made fun of the janitor, didn't they? Janitor, custodian, same thing. Withdrawal, substitution, and addition to collateral. Subject to the terms and conditions set forth in this section and the Public Funds Law. From time to time, the custodian shall, upon the custodian's receipt of a certificate of approval for withdrawal, substitution, or addition of collateral form, it's a request certificate, from a pledging bank meeting the requirements of this section, receive from and or deliver to such pledging bank or from or to such other party as may be designated in such certificate, such collateral with respect to the pledging bank in question as is listed in such request certificates. Each request certificate delivered by a pledging bank. So the request certificates are made by the pledging bank. And the pledging bank can name someone in such certificate. Withdrawal, substitution, or addition of collateral form from a pledging bank, meeting the requirements of this section, received from and or delivered to such pledging bank. Such collateral with respect to the pledging bank in question as is listed in the such request. Each request certificate delivered by a pledging bank shall be in form of Exhibit A attached hereto. Each request certificate shall set forth pledging bank in question, a listing of the specific collateral requested to be withdrawn, substituted, or added, a calculation of the aggregate market value of all collateral, after giving effect to the request or withdrawal, substitutions, or additions, a certification by pledging bank in question that the aggregate market value of all collateral, after giving effect to the request or withdrawal, substitutions, or additions, is equal to or exceeds the excess public funds. And that says excess public funds. Again, I want to ask, if they're bankrupt, how do they have excess public funds? A signature of an authorized signatory. Signature of an authorized signatory. Now you're a custodian, a banker, and a signatory. How about that? You're just playing the whole board, aren't you? Of the pledging bank in question. Authorized signatory of the pledging bank in question. What kind of requests are you making? Are you requesting that you register that car? Are you requesting that you apply for a job at McDonald's? Are you requesting that you be allowed to register your child at that school? Are you requesting that you be allowed to go to the hospital and receive inpatient hospital services under a spell of illness? Are you the form? Are you the literal manual form of the supply and demand chain? Are you requesting or demanding it? See, you really are the ones that are doing this shit. Like I said, if you quit doing it, they can't hold it against you. Delivery instructions for any collateral to be delivered to the pledging bank, or if the pledging bank in question does not intend to take or retain possession itself, the name, address, and telephone number of the person who will have ultimate possession of such collateral. So let's go down and look at Exhibit A. Exhibit A to Master Trust Custodial Agreement. Got date, pledging bank ABA number, telephone number, pledging bank's name, custodian, type of transaction, withdrawal of collateral, substitution of collateral, addition of collateral, withdrawal of collateral. Oh, look at that. They got QSIP numbers with maturity dates, addition or substitution of collateral. In accordance with the terms of the pledge and security agreement, we hereby pledge the following securities to the state treasurer as eligible collateral, and hereby use it as a request certificate, that birth certificate flipped over on its back with its request for full acquittance and discharge as a directive, so that no person be held liable in any court. Issue and coupon. What do you think those bills are? They say they're bills, but there's no bill on there. It's a statement of services, and it's in the form of a coupon because there's an original issue, and you get to discount what was counted. Total public funds deposits as defined. This is under required collateral market value. Excess public funds is A minus B. So you take the total public funds deposits as defined in Iowa code. That's A. And you minus the excess public funds. What are those excess public funds? Total public funds deposits. What are the excess public funds? That's the materialistic things like the cars and stuff that have to be converted at auction. The homes, that property, real and personal effects. It's amazing stuff once you learn what the implications are. Remember, folks, legal fiction is the presentment of the presumption of the facts presented to the court. That's all it is. It's a legal fiction, and it is the presentment of the facts that are presumed. They're all presumed. Every last bit of it's nothing but opinion. What they call law is nothing but comments on all kinds of paperwork, inventions, fabrications, and fictions to hopefully help guide people down a path that they can help control so they can control the people. All for their own prosperity and fame. Tontine banking principle. It's all going to one source. Everybody give up everything they've got. You won't own anything and you'll like it. Keep it up. You're doing a great job. Anyway, that's about it for tonight. I'll be back Monday night. I'm not going to do it tomorrow night. Tomorrow night will be Heckle Bus. I will be here for Heckle Bus at 10 o'clock, but we won't be covering the Master Custodial Agreement. We'll be doing something else. So in the meantime, I want everybody to know I love you, but I don't give a fuck whether you love me back or not. And I'm going to be coming back here shortly with some poker shenanigans. So if anybody wants to join me, I'll be posting a new StreamYard coming up. I'm just going to be sitting here playing some poker. And if people want to join the panel and talk some shit, let's do it. Meantime, remember, God bless and have a good night. We'll see you next time.